If your client is served, if you have a client, they must have 10 days notice before a hearing. And that is an automatic reset, if you will. If you get to court and they haven't had 10 days notice, you will get your 10 days notice for a hearing. If your client doesn't appear, the judge can't find them in contempt, but can get a default judgment against them and issue a capias, which is a civil warrant for his arrest. A bond, let's say that they are arrested, then the judge can set a bond, and this bond, unlike the bonds that we're used to, are cash bonds, and that money, if your client is found that owes that money, is going to go to the respondent. So they're not going to get their money back, that bond. That bond is gone, okay? And usually it's anywhere from $500 to $1,000, maybe $250 to $1,000, but if you can show that there are a substantial amount of arrears and the judge finds that it's reasonable, can make it $2,000 or $3,000. Okay? Because of the criminal nature of the punishment, people are appointed lawyers over in family courts. Probably, and if young lawyers here want to start doing family law or get in there, it's one way to do it is to do appointments on these kind of cases. Just now the legislature changed over there, so now they're using the wheel, kind of like I guess what we have over here. So you have to have some sort of certification and training, but you put your name in and you can get appointments for enforcement cases. A jury trial. Jury trials are kind of rare in family court, but in enforcements, if someone is seeking more than 180 days, then they have to do it by a jury trial or a jury waiver. Attorney's fees. So if your client is found in contempt, attorney's fees are statutory and will usually be granted, as long as they're reasonable. But I think what we find when we go over from criminal court over to the family court, that family attorney's fees are substantially higher. And so not only does your client have that hickey of having to pay $10,000 in arrears plus their current support, and then they're having to pay up to $20,000 in attorney's fees. So, you know, a lot of times when you counsel a client about that, it's like you can negotiate and reach an agreement on these things, and what you want to do is let them know that they're going to have that current child support that's due, they're going to have their arrears, and that's going to be tacked on to what they currently owe, and then they're going to have to pay attorney's fees. So that's when you kind of grovel with the other side and say, look, they don't have that much money, they're not going to be able to pay their fees, but they're going to be ordered to pay those fees. And what's going to happen is if you have an agreement or any regular order, you're going to have what we call compliance dates, so that the order will say, we're going to come back in 3 months to make sure that this person is in compliance. And if they're not in compliance, paying either the child support, the arrearages, or the attorney's fees, they could go to jail. And the courts really over there take this very seriously in terms of fees. So tell your client they really have to try to come up with some money or find a way to keep up with the payments. Now, most of the child support cases are in 4D courts. It's chapter 4D of the family code, and those courts are they're all in the old family courthouse. The district courts sometimes have their own, but most of the 4D cases are over there. And just know that if you take one of those cases, you're there forever. You're there all day. I call it the black hole of I don't know what, but you're there all day. So just know that when you go in, you can get there at 8 o'clock, but you might leave at 3. There's just so many cases, so many people. They tried to take attorney cases first, but you're just there all day. Okay? And if you get a case reset, your case is going to be reset for probably 4 or 5 months later. Okay? Which will give you time to prepare. And again, the rules of civil procedure. You can do discovery. You can do you can file for, you wouldn't do a deposition, but you could. The rules of civil procedure apply. So use that for your client. I found that divorce decrees and SAPSRs are these orders that are accessible to us just on the website are really good sources to find witnesses. I've found them in my criminal cases that because I do this, I know that if I'm looking for a witness, a girlfriend that I didn't know existed, not just running my client or witnesses on the criminal part, but if you run them on the family side and the civil part, you're going to find, oh, he had a a child with X, and you find X, and find out that he really was he was a good guy. He's paid his child support. I have found that this has been a really good source of character witness. I mean, baby mamas and baby daddies can come in and be quite helpful in our cases. And you don't know about these people all the time, but using these orders, you find, and you get addresses, because a lot of these orders have addresses. So if you can't find a witness, this is one way to find them. And then you look at these witnesses' Facebook and Instagram sites, it's amazing what you can find. So whatever you do, when you use the clerk's website, also look up the civil, because you never know what you're going to find over there. The other miscellaneous criminal aspects, in a divorce decree or an order regarding a child, a SAPSRA order, it says that any person that is going to live or that lives with someone who has been convicted of a Chapter 62 sexual registration offender has to report that to the other conservator. And it's been part of every order for several years now. The legislature added this year that if that person is going to live with someone who is a subject to a protective order, they also have to advise the other parent or spouse or former spouse of that information. And if they don't, it's a Class C misdemeanor, and it could be obviously grounds for custody modification. Now, that was basically it in terms of how, how I find the criminal cases can affect family law. Obviously, those are issues that, there are lots of issues you'd want to bring up in voir dire. I know that when, I try a lot of kiddie cases, and sometimes these allegations come up in custody fights. And it's important to bring that up, because I have a case right now where there's a custody fight, and just last Friday, the mom called me and said, "Oh my gosh, CPS is calling. They want to interview." They said they want to interview my daughter because my little boy said that Daddy touched him, or my new husband touched him, and that was last Friday, and it just it happened. CPS came in. They started interviewing. They found that it was unsubstantiated, so as of last week they dismissed it. But obviously that's going to have a detrimental effect. But as criminal defense lawyers, you might look at that, because how many times do we not have those cases where parents use these allegations for custody? And that definitely makes jurors start thinking. And it happens. It's happened to all of us. And so keep that in mind. In terms of practicing family law, as a criminal defense lawyer, I just want to say that it's a manageable practice to handle I think the proximity of the courthouses is definitely helpful, but also the fact that both of them kind of go hand in hand. You're litigating it in both arenas. You're both, you're trying to help people, but I will say this, the rules of civil procedure. We're kind of willy-nilly sometimes in criminal court when we just show up with our motions, or we fax them a couple of days before to the prosecutor and we say, "Judge, can we approach?" And we just have our, I want to bring up this issue. It does not work like that in family court or civil court. They're sticklers over there. You cannot just not show up in court. You must call in. You need to answer docket. You need to let them know where you are. There are some courts where if you have a hearing set and you may call and say, "I am in another hearing, I'm in another court and I'll be there," and you're not there by a time certain, they'll pass on your hearing. So I don't know I think it's true of any practice. Know your judges and know your courts. In family court, all of the courts, all the judges pretty much follow the local rules. And so the local rules that are in the back of the code, and they're also on the Harris County website. If you're going to start practicing family law, I would definitely print those out, because they're expected to be followed. If you're going to file a divorce with temporary orders and you're going to have a hearing, you need to make sure that you've complied with the local rules before you show up in that hearing, because some judges will say, "Counselor, have you complied with the local rules?" And you're thinking, what the heck are those? So if you're going to do it, just know that civil procedure book is going to be used quite often. Notice, You can't have a hearing without notice. You can't have a hearing without proof of notice. So, Judge, I told him, we talked about that hearing. He knew we were going to be here. Where's your proof of notice? Without proof of it, you're not going to have a hearing. E-filing. Everything now is e-filing. So the lawyers that were just doing uncontested divorces because they are easy, and they still are easy, everything has to be e-filed. So if you haven't learned, you're going to have to learn, because it's the only way to practice civil family law is e-filing. The only people that are exempt are pro se people. They don't have to e-file, but if you're a lawyer, you have to e-file. So learn how to do that if we haven't already. And also, the important thing about e-filing, and since I think a lot of criminal lawyers just do simple uncontested divorces, when you e-file your documents, just because you e-file it doesn't mean that it gets accepted, because there's so much e-filing now. So if you e-file, what you used to be able to do, we would just go up to court on the day of the uncontested, we're going to prove up our divorce, we take all our documents, give them to the clerk, and just go in front of the judge. Now you have to make sure that they're e-filed. And what we were doing was e-filing it the day before. Well, because they say those papers somehow have to go to Austin and then come here somehow, they don't make it in time. And the courts have been lenient about that, but they begin to tell us that if you haven't e-filed 36 to 48 hours before, you're not going to have your case heard. So I've been told that by several judges. So if you're going to do uncontested, continue to do them, but just make sure. And when you e-file, apparently it says that you've submitted your documents, but then you'll also get another email that says that they've been accepted. And so what you want to show is that you've been accepted. And I always take hard copies anyway to show them. But if you take hard copies and you say and you don't have the accepted, you may or may not be heard. So just keep that in mind. The other difference that you're going to find when you get over there is that we have associate judges over there. Every district court has an AJ, and that AJ is basically there to assist the district court judge with all the overflow. But that AJ basically hears everything that the judge hears. And so you need to know who your associate judge is also. And that, the only thing that when you would not want to go to, you may not want to go to associate judge, or you can use this as an excuse if you're not ready for trial and the judge isn't there, you can object to the associate judge on a final trial, and that way you have to get a reset. So that can come in handy sometimes. The other thing about family practice is that it's paper intensive, and we're not used to that in our practice, but it is paper intensive. The discovery can be very overwhelming, the deadlines, the motions, the judge sometimes say, brief me on this, the briefs. So to know if you're going to do a family law practice that you're going to be working much longer hours and on weekends. I remember I had who's now a misdemeanor court judge, said she thought she might want to do family law because she wanted to be able to spend more time at home. And I said, no. So she didn't do that. So yeah, I think is a big difference. Also, if you're going to do a family law, you really need to have a good paralegal, somebody that knows what they're doing, because you can't do it all. You can't do this, go to court, draft your pleadings, do your discovery without a good staff. What else? And pretty much, you don't flat fee in family court. It's all billable hours. You might start off doing it that way. I think I did initially because I didn't really know better. But you spend so much time that it's all billable. And I guess we're starting to do that some more in criminal. But know that in family court that you set a retainer, and you have to basically bill all your time. Okay? That's all I have, unless anybody has any questions. Okay.